The situation exploded fast. A reported 9-0 Supreme Court ruling on firearms instantly changed the legal gravity around permits, carry rules, and enforcement standards across the United States. And even though no law was physically erased overnight, the interpretation of what states are allowed to require, deny, or restrict has shifted, leaving millions of Americans uncertain about whether their permit process, their renewal, or even their current legal status will be treated the same way tomorrow as it was yesterday. A unanimous Supreme Court ruling is rare, and that rarity is exactly why this one is powerful, because when all 9 justices agree on a constitutional interpretation, lower courts, state governments, and regulatory agencies treat that interpretation as settled law rather than as a debatable opinion, which means that any statute, regulation, or permit system that conflicts with that interpretation is now legally unstable, even if it still exists on paper. And that instability is what people are experiencing as permit chaos. The court does not go into police departments and change their forms, and it does not go into state capitals and rewrite statutes, but it draws a legal boundary that every law must now fit inside. And when that boundary suddenly moves, every system built near the old boundary has to be inspected, adjusted, defended, or replaced, and that process takes time, creates confusion, and exposes contradictions that were previously hidden. One of the core tensions here is that firearm regulation in the United States is shared between federal constitutional law and state police powers, meaning the Constitution sets the limits of what states can do, but states design the actual systems. And when the constitutional limit shifts, the state systems do not instantly update, which leaves a temporary mismatch between what the law technically allows and what the bureaucracy still enforces. Imagine a state that used a discretionary permit system, where local officials could deny an application based on subjective judgments about need or suitability. And imagine that the Supreme Court now says such discretion must be narrowly limited because it burdens a constitutional right, and suddenly every denial based on that old discretionary language becomes legally questionable, even though the statute still exists. And that puts clerks, police chiefs, judges, and applicants into a legal gray zone. Some offices respond by freezing approvals until guidance arrives. Some continue business as usual, hoping nothing goes wrong. Some quietly loosen standards, and some become stricter out of fear. And the result is that 2 identical applicants in 2 different counties of the same state can receive completely different outcomes under the same law on the same day, which feels arbitrary, unfair, and chaotic, even though it is simply the system trying to rebalance itself. The 9-0 nature of the decision matters, because it sends a message that this is not a temporary ideological swing, but a strong constitutional signal, which means lawsuits will move faster, lower courts will align more quickly, and states will be under pressure to justify every restriction with historical precedent and constitutional reasoning rather than policy preference alone. That pressure triggers a second wave of instability, which is litigation, because advocacy groups on both sides immediately begin filing challenges, seeking injunctions, clarifications, expansions, or limitations. And each of those cases asks a slightly different question about what the ruling means in a specific context. And until those questions are answered, uncertainty remains. For example, one lawsuit may challenge waiting periods, another may challenge training requirements, another may challenge fees, another may challenge location restrictions, and each of these will travel through the courts separately, sometimes reaching opposite conclusions before eventually being resolved at higher levels. And during that time, the rules can change multiple times in the same jurisdiction. This is why legal change often feels like a roller coaster, rather than a straight line, because the Supreme Court decision is only the starting signal, not the final resolution of how the new interpretation applies to every real-world scenario. For everyday citizens, the most important thing to understand is that rights are not self-executing in practice. They are mediated through procedures, forms, offices, and enforcement systems. And when the legal foundation of those systems shifts, the systems wobble before they stabilize. That wobble creates delays, inconsistent enforcement, and confusion, and it also creates emotional reactions, because people interpret legal uncertainty as either opportunity or threat depending on their perspective, which amplifies fear, anger, and misinformation. Gun owners worry that their permits might suddenly become invalid or restricted. Gun control advocates worry that safeguards will disappear. Law enforcement worries about enforcing rules that might later be ruled unconstitutional. Judges worry about issuing rulings that could be overturned. Politicians worry about backlash. Media worries about clicks. And the public worries about safety, freedom, or both. In this environment, misinformation spreads easily, because uncertainty creates a hunger for certainty, and headlines promise certainty even when none exists, which is why you see dramatic language like shatters, destroys, collapses, or ends, even though the real legal effect is slower, narrower, and more technical. The danger of acting on those headlines is that you might either panic unnecessarily or take risks you should not take, because legal gray zones are not safe zones, they are risky zones, and the person who pays the price for misinterpreting them is usually not the politician, the judge, or the influencer, but the ordinary citizen. So the practical advice in moments like this is boring, cautious, and extremely important. You check your state's official guidance, not a viral post. You document your interactions with permit offices. You avoid assuming the most permissive interpretation. You consult a qualified attorney if you are unsure. You recognize that the system is in transition and behave accordingly. This is not surrender. It is self-protection. This is not fear. It is realism. This is how you navigate periods when the law is shifting under your feet. Another thing to understand is that constitutional law is not just about outcomes, it is about standards. And the Supreme Court often changes the standard by which laws are judged rather than the laws themselves. And that standard determines what arguments succeed in court. If the court says that a restriction must be consistent with historical tradition, then future cases will revolve around historical evidence. If the court says that a restriction must pass strict scrutiny, then future cases revolve around compelling interests and narrow tailoring. If the court says discretion must be limited, then future cases revolve around objectivity and predictability. Each standard changes the legal battlefield, and each battlefield takes time to map. That is why this ruling will echo for years, not days. Now step back and look at the broader pattern. This is not just about guns. This is about how constitutional change actually happens in a federal system. It happens through waves: a judicial wave, a legislative wave, an administrative wave, a cultural wave, and each wave moves at a different speed. The judicial wave is fast but abstract. The legislative wave is slow but concrete. The administrative wave is messy but practical. The cultural wave is emotional and unpredictable. When all four overlap, you get moments that feel intense, unstable, and dramatic, even when the underlying change is technical and procedural. This is one of those moments. So if you feel unsettled, that is normal. If you feel confused, that is rational. If you feel angry, afraid, or hopeful, that is human. But if you want to be protected, informed, and prepared, you anchor yourself not in emotion, but in process. You ask, what does the court actually say? What does my state actually require? What does my local authority actually enforce? What documentation do I have? What risk am I willing to take? These questions are not exciting. They are not viral. But they are powerful, because they turn chaos into navigation. And navigation is how you survive legal transitions without becoming collateral damage. The Supreme Court ruling did not end gun laws. It did not erase public safety. It did not abolish regulation. It did not guarantee unlimited access. It shifted a constitutional boundary. Everything else is the system adjusting to that shift. That adjustment is what you are watching unfold. And it will unfold unevenly, noisily, and imperfectly. But it will unfold. So the key points to remember are simple. There is a major constitutional ruling. It is unanimous and therefore powerful. It changes how laws are judged, not instantly how they are enforced. States are reacting at different speeds. That creates confusion. That confusion is temporary, but real. Your best response is patience, documentation, and verification. And if you stay informed, cautious, and grounded, you can navigate this moment without fear, without panic, and without putting yourself at unnecessary risk. If this explanation helped you understand what is actually happening beneath the noise, like the video, subscribe to the channel, and share it with someone who is confused or worried about this issue, because clarity is the antidote to chaos. Understanding is the antidote to fear, and informed citizens are always more powerful than reactive crowds.